Good morning and welcome to the Massachusetts Appeals Court on this Wednesday, October 15th, 2025. I'm Justice Ditkoff. To my right is Justice D'Angelo. To my left is Justice Wood. I know many of you are experienced, but not everyone, so I'll run through the ground rules. Each side gets 15 minutes. We have a clock there that will count down the time. When you have 90 seconds left, the light will turn yellow. When time runs out, the light will turn red, and we'll start counting up. If the light's red, that's not how much time you have left, that's how much time you're over. If the light turns red, finish your sentence, but don't say anything else unless you're answering a question from one of the judges, in which case, please do finish your answer. There's no rebuttal in the Massachusetts Appeals Court. We have read the briefs. We've looked through the record. We're familiar with your cases, and so you'd be best served by getting right into your argument. All that being said, I'll call the first case, number 24P 1170, Weir versus ERLAND Construction Incorporated. I noticed there's some medical records that are impounded. I wouldn't see any need to discuss the specifics of the medical records, but of course we won't because they're impounded. Counselor, whenever you're ready.
Good morning. May it please the Court, Attorney Chris Sobczak on behalf of the plaintiff appellant. We are here on a rather unique procedurally case by addressing a fundamental right, one of the most fundamental rights in our judicial system. It's the right to a jury trial. In most criminal cases and in many civil cases, individuals' right to a jury trial is guaranteed by both the federal and state constitution. And there are many rules that follow along it, how it's supposed to go procedurally, so we have orderly results of justice. A jury trial means that the questions that are in dispute, questions of fact, are determined by the jury. That's what the right to a jury trial means. In this case, the parties have litigated for years, and after multiple delays, including COVID delays, they were finally set to go to trial in January 2024 to have the jury determine whether the defendants were negligent, and if they were, what that negligence caused, what damages to all the plaintiffs. The defendants, ignoring the court's pretrial orders and the schedules, last minute decided to concede liability and moved for a bifurcation of the case. The court did so, and then the case proceeded to trial on damages only. But that's still a right to a jury trial. And then the issue of damages, what damages were caused by the defendant's negligence, and how much those damages would be fairly compensated for, was a highly litigated issue, was a highly disputed issue, and there is no dispute, it's a question of fact that needed to be determined at trial. In fact, the issue of that question of fact was not only relevant to the primary case, but it's also relevant to the next case against the other defendant, Liberty Mutual, because of the pending 176D case. Here, the trial went along not rather smoothly. It started off with the fact that the trial court denied the plaintiffs the right to their or statutory number of preemptive challenges. Then the trial was delayed for days to accommodate the defendants.
Counsel, I don't think we need to get into the specifics of what you claim happened at the jury trial that was right or wrong. What I'd like to jump to, and I know might be out of order from your perspective, but is the General Law, Chapter 152, Section 15 motion that you filed. I just want to make sure I have it procedurally correct. You filed that motion asking the judge, pursuant to 152, Section 15, to basically apportion the damages, and you gave 3 options. Is that correct? You filed that motion.
Yes and no, Your Honor. I filed the motion. I didn't ask the judge to apportion the damages. I asked the judge to approve one of the proposals, because this was not a settlement issue. This is an issue of a jury verdict. Therefore...
So all right. So you asked the judge to use the statute 152, Section 15. You are now on appeal saying that was improper, that the judge shouldn't have used that statute because that statute only deals with settlements, not jury trials. Since you're the one that asked the judge to use that procedure, why haven't you waived the issue of whether that's an appropriate statute to use or not?
Because the statute itself has been ruled in the past that is appropriate to deciding the amount. How it was used is what we're appealing for. The court doesn't get to decide what the facts are. The juries do.
What case do you have that says that after a jury trial, a judge can use Chapter 152, Section 15 as the procedure to apportion the damages?
There are no cases. That's because most litigants and most judges know in instances when you have a jury trial and there's a pending workers' comp lien, you have to use a special verdict form that allocates all the damages.
So do you agree that 152, Section 15 was not an appropriate statute to use?
No, I don't, because it's the only statute available. The lien still exists. There is nothing else there.
Couldn't you have asked for a separate trial against Liberty Mutual regarding the apportionment or how the lien worked?
I'm not aware of a separate right to a separate trial on allocations. The lien only attaches to something that has to be done. Whether it's a settlement or a judgment, there has to be recovery. If this was a true trial on both damages and liability, and in the end, the jury said there is no liability, then there is nothing to apportion. I would not be entitled to a separate trial against Liberty Mutual to have them determine what a portion of allocation goes to any particular money recovered, because there is no money recovered. The only time the recovery goes into effect is if there has to be some money to be recovered from.
Right, so we know the damages are $750,000, and if there's a factual question as to how much of that is pain and suffering and how much is economic, why couldn't you have a jury decide that?
We did. That's what we asked for.
I thought you said the jury didn't. I know you asked for that, but the jury didn't decide that. So why can't we have a jury trial after the first trial, to decide how much of it is pain and suffering, how much isn't? It's a
That's
factual
exactly
question.
what we're asking for.
I thought you asked the judge to approve an allocation, not to hold a second jury trial on dividing up the $750,000.
The way that the statute is presented is you present the options to what the court can approve if there's agreement with parties. There was no agreement here. Because the judge then substituted his opinion and decided the facts, that's unfortunately is what we're asking on the appeal, is that it's similar.
So I don't understand. So this motion you filed for judicial approval of third-party reimbursement, what was the judge supposed to do with your motion? What was he supposed to do?
Decide one of the options that were presented.
And he did, right? He picked He picked your third option.
He picked the third option but changed the facts, making it not only contrary to his offer, making it logically impossible. The judge decided, in making his factual findings, that somehow all $115,000 were allocated for in the verdict, at the same time ruling, actually, but the jury didn't decide those damages. Only the sum damages were included. So the court's decision was completely illogical, and it was contrary to what the rules called for. It is, unfortunately, one of the remedies is a jury trial. It's akin to what happens when you have a motion for a remediator or editor. If the jury decides on facts and decides, here's the verdict.
So could we say, all right, stay with the third option, but base it on the reasoning that was presented by you? Why isn't that the right? If the third option is a right option, just it has to be under your reasoning, why isn't the solution for us to say, okay, stick with that, but based on the reasoning that was given by counsel?
It is one of the options. If the judge's factual findings are vacated, one of the simplest options is we approve the last option, Liberty Mutual gets most of its money, and the question of what actual damages were awarded by the jury still remains undecided.
And am I correct that the reason the reasoning matters is because it determines how big the lien is, whether the lien counts for all that amount or just the part that was for the hand and foot? Is that why the reasoning matters?
It matters in two ways. At the first stage, yes, it matters to how big the lien potentially can be. So in this case, the court, injecting its own reasoning, made the actual lien logically impossible. You are taking something that you're saying is not allowed for in a verdict, and yet you're saying that all the bills that workers' comp paid for are somehow included. So you have a logical impossibility and the second issue is, which is why the defendants objected to it, and it's not before the court yet, is the subsequent 176D case. Here, the workers' comp insurer is not an innocent third party. It's also a defendant that was involved in the initial negotiations and making offers, and they're going to try to claim that their offers were reasonable based on what damages were and were not reasonable. And now they're going to try to use a judge's, not a jury's, finding of what the jury determined were the damages. So the determination of the facts is important here in both instances, the first phase of the case and the second phase of the case. The court just did it wrong. The court decided to take, first of all, ignoring the rules and actually took away from the jury. But once the court took away from the jury, went on his own, decided his own facts, deprived the plaintiffs of the factual determination, and made them such where Liberty Mutual gets as much money as possible, but they're protected as much as possible for the second case because half the damages are not related, even though they're getting paid for them.
How do we know what Liberty Mutual is going to get? I saw there was a motion that Liberty made to be paid $67,000, and the judge denied it. So how do we know that's what the amount is, or it might instead be the 37 or 34 that you're suggesting is the right number?
I don't think I understand the question.
So you're acting as if the judge found that Liberty gets $67,000. But how do we know that's true? All I saw was a motion for Liberty saying, give us the $67,000, and the judge said, no, I'm not doing that. So
The judge did. The amount was the same. So there was 4 proposals before the judge. There was 2 proposals from the plaintiffs that allocated the defendant's version of the facts. Only the first injuries are related. There was the 3rd proposal from the plaintiffs, using the plaintiff's version of the facts, that all injuries were related. And then there was Liberty Mutual's version of the facts, saying all the things are related, not going into details as to for how much was for medical expenses, for what type of medical expenses, just saying all 115s are allocated by the jury, they're just saying there's less for pain and suffering, so there'll less be of a future offset. The $67,000 number was proposed by both the plaintiff's 3rd choice and Liberty Mutual's choice. The only thing that was different is the court took the extra step, the unnecessary step, denying the plaintiff's right to a trial of deciding the facts that the jury did not have a chance to decide.
So it seems like you're saying that it's $67,000 because that's what all the parties agreed it was? Because the judge's conclusions just allocates, doesn't say anything about what Liberty Mutual gets.
It does. The $67,000 is what Liberty Mutual gets. That's the allocation.
Well, it says, for the reasons set forth above, the jury's $750,000 general damages award to plaintiff John Weir should be allocated as follows for the purpose of computing the reimbursement amounts: $120,000 to medical expenses and loss compensation, and $630,000 to pain and suffering. That's what it says. It doesn't say anything about what the lien is.
That's already before the court. Both motions provide a formula of how the amount comes out. And had the court just did that, we wouldn't be here. Because that basically means that the court picked the last thing. But the trial judge did the extra step, that is the one that deprives the trial of a jury, is of deciding what the facts are.
Can we pretend for a second that this case was a settlement? Under 152, Section 15, a judge does make findings of fact in that situation, correct?
Correct, but we can't pretend that.
So in this case, he has a number of $750,000. You file a motion with accompanying documents that says, here are 3 options, apportion it this way. They file oppositions with documents, and then based on the documents, the judge makes findings. What is wrong with that?
Because that's just not the facts. We can't make up facts. That's not how the courts work.
He didn't make up
facts.
We did. He used the accompanying documents that you submitted in your affirmative motion to use this procedure, and he used the documents that were submitted by the opposition. If it was, again, pretend for a second this was a settlement. Isn't that exactly what a judge does in a 152 Section 15 proceeding?
If it was a settlement, that means the plaintiffs agreed to that number. That means we did not go to trial.
The number is agreed to. It's
not.
It's $750,000. That's what the number is. How it gets divvied up, that's the question here. We all know the number is $750,000. You yourself agree you're not appealing that number. So the number the judge has to figure out on the apportionment is $750,000. What difference does it make whether it was a settlement amount of $750,000 or the jury award of $750,000? Once he has that number, he now has to make findings based on the submissions as to how it should be allocated. Isn't that what a judge does in a 152-15 proceeding?
Not in a jury trial. That's why we're here. It's not a settlement. The $750,000 was never agreed to by the plaintiffs. The $750,000 was never offered by the defendants. That's the number that by law, by federal and state constitution, the jury decided and the jury's supposed to decide the facts. We don't get to lose a right to a trial saying, well, we'll give you a taste of your rights, but we're going to take the other ones away and let the judge figure out how he wants it.
Can I jump in here and ask, do you have a case? There's no dispute that you got a jury trial. There's no dispute that the jury determined the damages. The jury might have even determined allocation, but not because your request for a special verdict form was denied. Assuming you preserved your right to a jury trial on this question because you requested the special verdict form and the judge rejected that, do you have a case that supports the notion that the right to a jury trial extends specifically to this factual context of allocation? Because we know, for example, that judges can reduce jury awards. So it's not clear to me whether the right to a jury trial extends all the way to, as far as you want it to the right to an allocation.
There is no trial, there is no case in Massachusetts yet in the Section 15 context. What the closest thing is, and I didn't put in my briefs yet, is the issues like you just mentioned. The judge could reduce the verdict. But if a judge reduces the jury's factual determination, the plaintiff has to accept it. And if the plaintiff doesn't accept it, you get a new trial. That's the cases. The closest and factually and legally analogous situation is if you are taking a factual finding in a case where you have a right to a jury trial, and you say, here's what the jury decided, the judge, for whatever reason, saying, no, I'm going to substitute my decision for that of the jury, you, the offending party, have a choice to accept it, and if you don't, you get a new trial. That's why we're here. We don't accept the judge's substituting himself for the jury, and therefore, unfortunately, the most basic thing is to get a new trial. I offered there are some other more simpler
time is run. Unless there's further questions, we will hear from Liberty Mutual Insurance. Thank you, Counselor.
If it please the Court, Paul Valentino on behalf of Liberty Mutual, the workers' comp insurance carrier. I think you hit the nail on the head. This Chapter 152, Section 15 provides for the allocation of pain and suffering.
In a settlement.
I believe the cases also provide when there's a verdict.
Do you have a single case from our appellate courts that says that 152, Section 15 can be utilized from a jury verdict?
In plain, simple words, no, but I did cite the Wesco case, and I believe it was Perico that offered that preposition. I don't think my brother has questioned that.
We do.
Okay. Well, I think the cases that I cited in my brief address that.
Let's assume, well, even if that is an issue that we are intrigued by, has the plaintiff waived that right by submitting the motion?
I would agree. I think if he was aggrieved with, as I noted, Liberty wasn't part of the underlying trial. If he was aggrieved with the judge's ruling about a special verdict where pain and suffering is not allocated or addressed in a verdict slip, he had a remedy. He ignored that and went to the Section 15, filed his petition for approval. The judge allowed it, and
so what he should have done on your argument is let's assume for a second it was properly preserved at trial. He objected repeatedly. He should have just appealed the verdict, and that was it.
Right. I think he certainly did waive it by filing his petition for approval, and I think the court's ruling in that does, the judge's duty in the Section 15 hearing is to either accept or reject the plaintiff's petition for the allocation of pain and suffering, and that was done.
Sorry, but if he raises, picking up on Justice D'Angelo's point, if we agree that he preserved the constitutional claim, I have a constitutional right to have the jury allocate this in a special verdict form, judge denies it. You're saying he can't then, let's assume that 152.15 applies, is a viable option here, or it's not clear whether it's a viable option. You're saying simply by asking for that, he waives the constitutional claim. It seems to me a different argument could be, well, no, he's preserving that issue, but in the meantime, he's trying to get an actual solution, because you have to have a solution. You wanted a solution. You need a solution, too, because you need to know how much of this we get back, right?
Yes, but I think he puts the cart ahead of the horse. He goes to the court for the approval of a Section 15 and then turns around and says, that's no good. I mean, and I think the judge was, in the Section 15, and his rulings were very clear, concise, and I think it did point out the allocations that he asked for were accepted. The $630,000 for pain and suffering, that was accepted, and filters down to $67,000 and change that Liberty would recoup. I think in his conclusion, he doesn't specifically say that, but within the body of his ruling, he addresses that.
I just want to ask, he also says, 2 paragraphs before the conclusion, Liberty Mutual also is entitled to receive a proportional share of the interest awarded in this matter. I think I'm understanding. In other words, it's not, that's the $67,000 is not everything Liberty Mutual gets.
Well, Chapter 152 provides that the apportionment between the insurer received by them respectively, exclusive of interest, wasn't brought up at the hearing, but I think he addressed it when I filed the motion seeking the court's order for him to pay the $67,000, and the judge denied my motion that was noted, but did indicate that I would be entitled to interest at that time.
Okay, thank you.
Is the only appeal that you believe is sort of ripe for our consideration is whether the judge abused his discretion on the apportionment under 152.15?
I think that would be the only basis for an appeal. I don't think...
I understand you don't agree that there was an abuse of discretion,
Right.
but that's really the only issue that you say
Right.
is ripe for us to consider.
Yeah. Right. I think the judge followed the case law in Chapter 152, Section 15 to a T, and issued a concise order outlining his duties with regard to allowing or denying a petition in that respect.
Sorry, go ahead.
Let me ask you to ask your friend, is it clear that Liberty's share is $67,000 and change, or is that still up to further litigation?
I think that it's clear in the judge's ruling, I think on page 3 into 4, when he goes through the various scenarios about the plaintiff's suggested allocations for pain and suffering, he eventually lands on the 630, and under that variation, Liberty, after fees and costs, would be $67,146.66. And then in paragraph B, the next one on page 4, he again notes with the allocations that he's accepting, the net payment due Liberty Mutual after fees and costs would, using that same
I see.
allocation from his third scenario.
Can I ask, if we conclude that 152.15 is not appropriate in this context, that it only applies to settlements and not verdicts, there's still the problem. Can you remind me, does the briefing of any party suggest a third way? If it's not a jury, it's not 152.15, the problem is still there. I think everybody agrees. How much money do you get back here? And everybody agrees you get something back. So how does the judge, what's the mechanism? Is there,
Short of Chapter 152, Section 15, I have no knowledge of any other mechanism.
nor do I.
All right, thank you, Counselor.
Thank you.
We'll hear from Sean Lee now.
May I please the court? Scott Zanoli on behalf of Pelley Sean Lee Construction. So I want to start first by saying it's my understanding that the plaintiff in this case, Mr. Weir, is not appealing the verdict that was rendered by the jury. And thus, the appeal is really limited to this issue of allocation of the workers' compensation loan.
He's also appealing the satisfaction decision. He claims that you owe another $20,000 or more, as far as I can tell.
Of course. So the first part is of the workers' compensation allocation, which is based on his challenge of the verdict slip, and then the second portion is the challenge of the court's order on our motion for Sean Lee's motion for satisfaction of judgment, which was allowed on or about May 16th, 2024. As it relates to the motion for satisfaction of judgment, the court's entry of satisfaction of judgment, the court clearly stated in its decision of May 16th that Mr. Weir had raised this issue of post-judgment interest, and the court had essentially said that whether or not there is some additional amount of post-judgment interest due is not relevant or material to the decision of whether the satisfaction of judgment has occurred. Of course, judgment entered in this case in February of 2024, February 26, in the amount of $1,712,391.09, and Sean Lee tendered payment to Mr. Weir and his co-plaintiffs on or about March 6th in an amount that exceeded the amount listed in the judgment.
That's how I read the judge's decision too, but that would suggest that Weir could still go after you for post-judgment interest, could still ask the judge to find that you owe more post-judgment interest. It just wouldn't affect whether that judgment was satisfied.
Well, if he had a basis to pursue additional post-judgment interest, in theory he could bring that before the trial court. I do not believe it's an appropriate vehicle by which to challenge the entry of the satisfaction of judgment after payment of the judgment. It would be a separate proceeding.
Right, it'd be a different vehicle. This is the wrong vehicle, but it's not that he doesn't have a vehicle to litigate whether you owe more post-judgment interest, right?
I would agree, and of course we would disagree on the merits that he is owed additional post-judgment interest, but having said that, the procedural vehicle for that would be a challenge at the trial court level, not an appeal of the entry of satisfaction of judgment, because, of course, Sean Lee had paid an amount that surpassed the amount listed in the judgment. So, going back, because there's been quite a bit of discussion on the issue of the allocation. Again, Sean Lee is not interested in the allocation exactly, but Mr. Weir's challenge relates to the court's denial of his request for a certain verdict form. And of course, we would say that that decision is reviewed for an abuse of discretion, and here Mr. Weir is unable to establish an abuse of discretion. That is,
really, it seems pretty bad to not have the jury make an allocation when he was told that it would resolve all this litigation. I mean, that's what counsel told him. He was right. If the judge had just done a verdict slip that distinguished between pain and suffering and economic damages, we would have solved all these issues. It seems kind of an abuse of discretion to buy all this litigation, don't you think?
Well, the decision would have to fall outside the range of reasonable alternatives. And so certainly he has a broad measure of discretion in fashioning the verdict slip, and he took a thoughtful approach, which was concern over confusing the jury. And
I guess that part of the argument confused me. What was so confusing about it? The verdict slip apportioned it very clearly what it was for. The arguments of counsel at trial were very clear on what they were asking for certain apportionment. Why is that so confusing for the jury?
Well, I think the court's reasoning specifically was that breaking it out into separate sections in a manner that was, lengthy and complicated would conflict with the instructions that he had issued with respect to damages. And certainly, again, it would be susceptible to misinterpretation by the jury or some type of suggestion that damages should be allocated in one way or the other. And again, so long as it doesn't fall outside.
But I don't get how a jury in a case like this can even decide damages without figuring out what's economic and what's pain and suffering. Like, I don't understand that. Wouldn't a jury mentally have to decide, okay, here's how much is economic, here's how much is pain and suffering, and then add those together? Like, is there any other way a jury could decide the damages?
Well, if they take Mr., well, in theory, they could decide the damages by accepting the plaintiff's position on the economic harm that was caused, of course, the medical bills and his alleged lost earnings, and then come up with a number for pain and suffering, obviously, and do as they did here, which was put them together in one comprehensive.
But that's what I don't get. If the jury has to do that math in their heads anyhow, why wouldn't we ask them to tell us what they came up with, which then avoids all this litigation?
Well, Your Honor, I think it is an alternative to what was proposed by the court. It certainly is an alternative. I would say, though, that it is, Mr. Weir is unable to establish that that is either, the fact that that decision could have been made by another court or may have even been made by this court, is it really what governs? It's a decision that is made outside reasonable alternatives. And in this instance,
The reasonable alternatives are separate out the numbers or give us one big number. Those are the two alternatives in this case. And you're saying that the one that separating out the damage amount was within the discretion.
what I'm saying is that the decision made in this case doesn't fall outside the range of reasonable alternatives, meaning that, giving an option for one category or one order of damages is one of the reasonable alternatives in this case, right? It's not so far out afield that that in and of itself could be a basis for an abuse of discretion decision.
All right. All right.
Thank
Thank
you,
you,
Your
Counselor. Thank you all. We will take this under advisement. I will call our second case, number 24P 1259, SHASTRY versus SHASTRY. Let's just give your friend a chance to get set up. All right, Counselor, whenever you're ready.
Morning, Your Honors. Michael Judge, may it please the Court. Michael Judge of Ligerson Associates here on behalf of the appellant. With me as co-counsel at the trial court, Ariana Flessis, Your Honors. Your Honors, by this appeal, we're asking that the court consider reversing the decision of the Middlesex Probate and Family Court, Your Honors. The reason why we're asking for that is we believe there's been an abuse of the discretion of the court because the judgment does not flow rationally from the findings. As Your Honors are aware, this was an alimony modification filed by the appellee, the former husband, Your Honors. The basis for his modification action was that he had received a substantial reduction in his income and that my client's income had been increased. The fundamental purpose, as Your Honors well know, for alimony is you have one spouse who is in need of support and you have a supporting spouse who has the ability to pay. In this case, the real focus is my client's need, the need that was established by the court in the finding.
Can I change the facts a little bit?
Yes.
Let's assume husband's income hadn't changed at all.
Yes.
But wife's had doubled, which is basically what happened here.
Yes.
Wouldn't that have been an appropriate action for the husband to file a modification to say the alimony needs to be changed, her income is doubled, and therefore she can pay a certain portion to basically say, stay to the life to which she was accompanied at the time of divorce?
To file the modification, yes, Justice D'Angelo, but to receive the relief that was achieved here, I would say no. And the reason why is because the findings are clear. At the time, need is based upon at the time of the termination of the marriage. Finding 44 specifically finds that the need is $7,706 per week. That was the court credited.
Can you say that again? What was the finding of fact number?
Finding of fact number 44.
And the need at the time of the divorce, is that what you were?
That's correct.
And you said the need at the time of the divorce is how much?
The trial court found in finding number 44, $7,706.
Hey, that's not what it says. That says, per his divorce financial statement, the husband's expenses totaled that.
And the court credited that that's what the need was at the time of the separation, at the termination of the marriage, Your Honor.
Where's,
Found that
okay,
my client,
where's that?
and my client found.
No, where's that? You said the judge found that that was the husband's needs.
That's correct. And in
So where did the
findings-
judge find that?
And in finding 68, found that the number that my client had listed showed that she had very meager conditions, and that for the expenses that she listed on her
Right.
financial statement.
Wife testified credibly that $2,885 is too low.
Correct.
So,
But I don't see where the judge found that anyone's needs were actually $7,709, much less your client's needs.
Could I direct you to finding of fact 70? Because this is what I'm trying to peg this to, and admittedly, this is kind of confusing. But when asked about the weekly expenses reported by the husband on his divorce financial statement, which I think is the document we rely on for at the time of divorce, that's the needs that
Yes.
we're concerned about, amounting to, the husband says, $37.97 weekly, including voluntary retirement contribution of $692, totaling approximately $4,500 a week. The wife concurred that this figure more accurately reflects the weekly expenses of the parties' marital lifestyle. So to me, that's, in the sea of numbers, the most reliable thing to peg my hat on, which is, so in other words, $3,800 a week before the retirement contribution is, it seems, what everybody agrees, at the time of the divorce, the weekly expenses. Now, the number you just threw out is like wildly different than that.
It is, Your Honor. And if you could look at finding 48, that's when you add in also the deductions from his pay.
Why would I add in deductions from his pay, unless if they're voluntary?
Because those are the expenses that are taken off of his gross income.
But that's not
Those are the-
expenses for the family, for the household.
Okay, Justice Wood, even if I go with what you're addressing directly, which is the expenses that each party lists on their financial statement as expenses that go directly to the household, finding number 77 shows that at the time of the modification trial, the expenses are $4,044 per week, and that my client's net earnings plus the $1,000 a week that she's receiving in alimony is $3,081. That's finding 77, leaving my client at a shortfall of $962.
Oh, no, 77 says that's what the wife reports.
Right.
Correct.
And then he finds later that she's overstating
Right.
her expenses. And she's got to be because her assets aren't going down.
Right.
So,
And furthermore, wives, it seems to me the next most important thing is a reliable number of the wife's net income without voluntary withdrawals, in other words, not the daughter's graduate school payments and not the emancipated 30-year-old daughter's grad school payments, and not her own retirement savings, come out to $3,580 a week. And then that's just below the $3,800 in reliable weekly expenses at the time of the divorce. And the judge says, right, add that to $580, and now we're a little bit over, which seems rational, a little bit over your weekly expenses at the time of the divorce. And so you can save a little bit, and you're meeting your needs. To me, trying to get through the morass, and I could be wrong, that seems like that was a reasonable process the judge went through. And so why am I supposed to, what's wrong with that I'm supposed to reverse it?
So I believe, Justice Wood, that the number that you're using is not inclusive of the deductions that she had from her withholdings for contribution to her retirement account.
Right, and why should we include those? The judge
That's
made the point.
because-
Go ahead,
I
sorry.
apologize.
No, my fault.
No, Justice Wood, because those are based upon the judge's finding in 44, which is it goes to the marital need and the marital lifestyle under Openshaw, I would suggest, and also Young. At the termination of the marriage, the expenses of the parties were, as I stated earlier to Justice Ditkoff in finding number 44, the husband had reported $7,706 per week in expenses.
Right, sir, I'm not conceptual, I guess it's a conceptual question then. What you were just talking about, we all understand in a concrete sense, there's two withdrawals that I'm not counting and that you say we should count. Her retirement contribution to, I guess, a 401k, something like that, and then the stock option to purchase stocks.
Correct.
Though I don't understand why those should count, because those are not needs, those are choices to, that's not food, clothing, shelter. That's that's the desire to save for the future. Why should we include that?
So I would suggest, Justice Wood, that is part of the party's marital lifestyle. That is what they had done. They had done that throughout their marriage. They did that. It's noted on the party's divorce financial statements that they were contributing to retirement accounts, and I would suggest that is part of their need under our case law.
Can you give me a case that says that? That would be helpful.
I believe Openshaw would discuss that, where continued contributions, that's part of their marital lifestyle.
Okay.
And
Thank
Thank you, my pleasure. Justice Ditkoff, to address one point that you just raised a moment ago, where my client is not, and this was something I'd like to address from the appellee's brief. It says that my client is not dipping into her savings to fund her lifestyle, but rather the argument is that she's saving. I would strongly suggest to the court that that's not accurate. At the time of the party's divorce, my client had $1,273,000 in assets. We know from the separation agreement that she owed her ex-husband, the appellee, $240,000 roughly, to buy out his interest in the marital home. That would reduce my client's assets to $1,033,000. At the time of the modification trial, she lists that she has assets of $1,208,000. So an increase of $176,000 in her asset base. That comes from two things. One is, at the time of the divorce trial financial statement, which was a 1A agreement, the marital home had a fair market value of $700,000. By the time of the modification trial, my client lists the home as having a fair market value of $800,000. So that takes care of $100,000 out of the $176,000 increase. Also, my client had a rollover IRA that appreciated by $75,661 from the time of and that's not because of contributions, that's strictly...
I'm sorry, could you give me that number again?
Sure, $75,661,000. That's how much her rollover IRA, which she was no longer contributing to, appreciated from the time of the party's divorce until the time of the modification trial in December of 2023. So, Justice Ditkoff, I would say that my client was not saving money. She would rather two primary assets, a former retirement account and her marital home, had simply increased in value based upon market conditions. Next, so we come to the conclusion. We have these findings, which I know all the justices are, it's clear that my client is not opposed to any of the findings that the judge has. But there's two findings that the judge specifically makes. One is that the father was living in California at the time that he voluntarily withdrew from his employment at Berkshire Hathaway and moves to the state of Texas, where he no longer has a 10% state tax, which the husband acknowledged, the appellee acknowledged was going to save him up to $50,000 per year. And the court also has specific findings of fact relative to the contributions by a household member of $4,000 per week, which was not referenced or listed at all on his financial statement.
Conceptually, help me understand. There's obviously, well, just to cut to the chase, the judge very clearly allocates to the husband his original income from Berkshire Hathaway. It says, forget about this new job. I'm going to allocate the income from Berkshire Hathaway. the fact that he takes various steps to reduce his income by making his new girlfriend kick in half of the expenses, for example, seems to be another one in this category. His expenses are going down. Why is that relevant to us conceptually for the wife's needs?
Very good. It goes to his ability to pay. And if I may, with the utmost respect, just I have to correct just one thing, Justice Wood, because I think it's a little bit lost here in the judgment. Justice Wood, you just referenced the fact that the judge said just because appellee lost, his income was reduced, we're going to keep it at the income that it was at Berkshire Hathaway. That's not exactly what the trial court did. The trial court said, I'm going to impute to him or attribute to him his base income, not all income. And what I think is important is just that. Nothing within this separation agreement says that we're going to exclude any income whatsoever. The separation agreement just states appellee is going to pay Appelon $1,000 per week.
Maybe I'm missing it, but it seemed like the judge's decision was based solely on the wife's needs, and it wouldn't matter if the defendant was making $1 billion a year, because she treated him as able to pay whatever it took to meet the wife's needs. Am I missing that? I didn't see any part where he discounted it because of the husband's ability to pay.
So I would disagree with that, Justice Ditkoff, and this is the reason why. The judge at the trial court level did not specifically say this is the wife's need that she needs to make up. She basically said, here's the disparity in the parties' earnings, wife's base pay, husband's base pay at his old job without factoring any of the other income in, and we're just going to do 20%, because that's exactly what it is. It's 20%. The parties' disparity in their base salaries is $150,000. The court does 20% of the difference of that. So it doesn't, nowhere within the decision does it say this is what the wife's need is. In fact, finding 77 states that based upon what wife's reporting on her financial statement, she has a $962 per week shortfall after the receipt of her $1,000 in income, in alimony, per week.
Yep. Well.
And so by reducing her support by 42%, the judge not only takes the $962, you add on $420 to that, leaving her.
But you pointed me to Openshaw, and I'll go back and read it, about voluntary retirement contributions. But then there's also the contribution, when you get to that $962 number shortfall weekly, that includes, I think, the $450 a week loan payment for the daughter.
Right.
Is that also covered by lifestyle of the parties at the time of divorce?
No, I would not suggest that.
So that is, you subtract that $450 from the $962? Is that fair?
That would be fair.
Okay, now let me go back before time. I know your time's almost up. I had a different question. Can you direct me in the separation agreement, going back to your comment about bonuses? I hear what you're saying. The husband was getting, a lot of his compensation came in bonuses. And you properly referred me, and I remember this, to the base pay. The judge tied all this to base pay.
Right.
There was also reference, though, and I can't remember if in the separation agreement, I looked this up, that the parties agreed amongst themselves in the separation agreement that bonuses would be excluded from all calculations.
No, I don't believe that's accurate.
You don't think that's accurate?
No.
Okay. I'll go back.
I believe specifically it's Exhibit A of the separation agreement, and the separation agreement just states the amount that's going to be paid is $1,000 per week. It has the provision 2, paragraph 2 has the termination language, and paragraph 3 deals with the tax effect of the alimony.
Okay.
All right, thank you, Counselor.
Thank you, Justice.
We'll hear from the husband now.
Good morning, Your Honors. I'm Maureen Booth. I represent ARUN SHASTRY. He's the husband in this case. As this court knows, the statutory authority to award alimony is grounded in the recipient's need of support. Need, under general term alimony, is the amount required for the recipient to meet her standard of living, as the justices just pointed out, at the time of separation. And as the court just reaffirmed yesterday in De Felipe versus El Yusuf, a case which Justice Wood sat on the panel of, that in fact is the definition of need at the time of separation. Your Honors just pointed to finding of fact number 70, and I looked at that closely last night because that's interesting in that it's made up of not only husband's, if I can flip to it, husband's expenses at the time, it's also made up of his voluntary retirement contribution, which totals approximately $4,500. And that is indeed what the wife said was approximately, she agreed, was approximately their standard of living at the time. So to do an apples-to-apples comparison, Your Honors, to me, we would take wife's expenses now and her retirement contribution as her need at this point. And Your Honors, if you do that math, which I did last night, that totals $4,477, $12 difference from what.
So, Counselor, I think that's right, but your friend makes a good point that that's not what the judge said. The judge didn't say, hey, I figured out what the needs are, and we need $580 a week to reach the wife's needs. Instead said, I'm going to do 20% of the income disparity. And I don't get why a judge can do that. It seems to me in a case where there's ability to pay, the only thing the judge should have been figuring out is what are the needs and is setting it for that number.
But, Your Honor, in fact, if I may disagree, Judge Cafazzo did not say 20%. She said $580. Her exact comment was, this court finds, and it is a finding, that alimony should be reduced to $580 weekly, which is approximately 20% of the difference between husband's attributed income and wife's base income.
So you're suggesting that wasn't the rationale, that was just a That's in the rationale,
Your Honor. That's on page 17.
No, I see it, but you're suggesting the judge isn't saying that's why I'm making that number, just pointing out that's what the number is?
I believe, Your Honor, with 89 findings of fact, and then the close look that Judge Cafazzo, after hearing the evidence, that she looked at what the wife's actual need was and chose 580. She didn't just use 20%. And, Your Honors, it's in the testimony. I'm not sure it's in the findings, but I read the whole trial transcript yesterday, that was approximately 20% of the original. 1,000 was approximately 20% originally. So that maintained that differential. But more importantly, knowing that we're supposed to look at need, not necessarily a percentage. And that's exactly what Judge Cafazzo did. And she focused on the discretionary expenses, as Your Honors have focused on this morning as well. And there are numerous indicia that wife herself does not have need. Her expenses have gone up. Not only have her deductions from pay gone up, voluntary deductions, as you have pointed out, Your Honors, her retirement has gone from $250 at the time of the divorce to $432 voluntarily withdrawn from her paycheck. She now takes an FSA account, and she has the employee stock plan for $283 a week. That totals $520 voluntarily taken from her pay. Even after that, she paid off $150,000 of her mortgage, but her mortgage, despite that, her mortgage payment has gone up from $550 a month to $759 a month. Food has gone from $250 to $300. House cleaning from $47.50 to $100. It goes on. So all of her expenses, Your Honors, have gone up. Her children's education, as Your Honor pointed out, she's paying $401 a week for that. Education for herself was at $0, now it's $150. So these are all, as Justice Wood pointed out, these are discretionary expenses that is not an indicia of need.
Does it matter that under open shot, does it matter if they're discretionary, or does it matter that they're discretionary that don't reflect the kind of discretionary payments being made during the marriage?
I would suggest, Your Honor, that these are not expenses that were made during the marriage.
But wait a minute, I'm learning here, so this is helpful for me. But you just said that in Finding of Fact 70, you helped me notice this, the weekly expenses are $4,500, including husband's voluntary retirement contribution of $692.31 a week.
Yes.
So to make it apples to apples and to follow Openshaw, I think we are supposed to include her voluntary employment savings. So what you just said, those are discretionary. I thought they were initially, but now I've been educated. And so I think we need to be all on the same page. Those, we count those, right?
Yes, Your Honor. And
Okay.
I was trying to say, if we're going to use 4,500 as the lifestyle marker, we have to include that 630, whatever that figure is.
692.
Yes. And so we have to include wife's retirement contribution as well.
Right.
And that was that
Oh,
argument
okay,
there.
gotcha, I'm with you now, right.
And
yes.
that actually gets her to $4,477 a week as well, the same as that would have gotten the husband to 4,500, approximately 4,500.
Right.
If that
I get
logic
that.
makes
Gotcha.
sense. Yeah.
Thank you.
Okay. So obviously, as this court knows, what the judge found is not that the wife needed, that there was need, but that there was some alimony. And as this court found in Zaleski, and I'm quoting, a judge has broad discretion in determining the amount of alimony to be paid by one divorcing spouse to another. And that's exactly what Judge Cafazzo did. After careful examination and looking at the evidence in this case, and 89 findings of fact, supported by conclusions of law, she determined that $580 is the amount needed by the wife. And you can see that, the wife had the benefit of the level of $1,000 throughout. She started that job actually 5 days, I think February 5th, and the divorce judgment was February 12th. So she actually started the job before the case went to judgment. So she was getting $1,000 during the entire pendency. My client still didn't file his complaint for modification for another year and a half after that, until his income changed. So she had the benefit of that, and then not only that, she got the benefit of the amended modification with the retroactivity, which was another $23,520, Your Honor. So because Judge Cafazzo made it retroactive only to the date of trial, not to the date of service of the summons. So she has gotten the benefit of the judge's reconsideration throughout this, and I believe that is reflected in the wife's spending and in her discretionary purchases and, her ability to pay her daughter who lives with her, who's 30 years old, and we don't know what she's contributing. Apparently, there's nothing on the financial statement there, but, she's able to pay off her expenses and able to spend $150 a week on personal grooming and haircuts, things like that, which that's fine, but that's certainly not an indicia of need. And as this court,
I was curious, something your opponent said, I was asking about the husband's behavior, and he said it's relevant to the husband's ability to pay. I had been focused on need, and you're focusing us on need.
Yes.
What do you say to that it's the husband's ability to pay is relevant?
I believe that under Young, Your Honor, and I think your question begs the point, that under Young, it almost wouldn't matter if he made $1 million, to the question that the panel asked, because it is capped at the lifestyle of the marriage, not I'm finding the words, the upward trajectory. And the lifestyle of the marriage is the $4,500, or even, Your Honors, the wife on her financial statement indicated that, on her trial financial statement, that in footnote 3, that, let me find the exact reference, I'm sorry, one moment, please. That she says the weekly expenses, the historical figures are during the marriage, and that figure is $2,800. So that's her trial financial statement. I'm sorry, her divorce financial statement, Your Honors, and that her expense figure there is $2,800. So that, I guess there's.
Right, but that was significantly under, the judge found.
I'm sorry, say it again?
The judge found that was significantly under.
She did, she did, Your Honor, but the wife was saying in her financial statement that these were the figures that were such as $192.31 on vacation. The wife said in her financial statement that those were the figures from the marriage. That's the wife's own words. So, whether it's $28,885 or $4,500, the wife's income is clearly above that. So, I would say that she is not entitled to a, to more than what Judge Cafazzo found in her close examination, that 580 is the right amount, that some alimony is needed here, but it's not $1,000, that this reduction is appropriate, and I would ask the court to affirm Judge Cafazzo's judgment. Thank you.
All right. Thank you, Counselor. Let me say two things. One, I know you're both primarily trial attorneys, but this was really helpful to the court, both of you, and I really hope you do more appeals, both of you. Let me just say one thing to you, Attorney Judge. Your brief is labeled partially impounded on the front, but it's not impounded in our system, and it wasn't clear to me why you want it impounded. So if you do want it impounded, you're going to need to file a motion explaining why it should be impounded. Right now, it's public. Not that people are clamoring to look at it, but just be aware of that. All right. Well, if you want it to change, you need to file a motion. Thank you both. All right, I'll call the third case, number 25P59, Nickerson Werner versus GB Nickerson Insurance Agency. Whenever you're ready, Counselor.
Good morning, Your Honors. I'm Attorney Kevin Withers. With me is Attorney Michael McDonough. We represent the plaintiffs in this case, Jackson James and Elizabeth Werner. This case initially arises out of a motor vehicle accident in which Jackson Werner suffered serious bodily injuries. His parents, James and Elizabeth Werner, had claims for loss of consortium. But the nub of the dispute here involves the plaintiff's claims that defendants, their insurance agents, made false and deceptive representations to them that resulted in the plaintiffs having insufficient underinsured motorist coverage to compensate them for the injuries.
Can we get to one of the issues that the appellee brings up about the timeliness? In your brief, you say that something was ambiguous about a docket entry. What was ambiguous? Can you point me what was ambiguous about it? Because I miss it.
Well, I think the docket entry was actually clear. It clearly says judgment entered in October of 2024.
Well, no, it also says a judgment entered in June or July, I can't remember, 25th, 2024.
Well, that's the plaintiff, the defendant's argument here. I understand that.
No, that's me looking at the docket.
Right. Looking at the document, that appears to be a docketing of two things: the judge's allowance of the motion for summary judgment, and then the judge's order that the plaintiff's claim should be dismissed. But entry of judgment for purposes of appeal is the clerk's action, not just the recording of what the court did. And clearly, if you compare those entries to the October entry, I submit the July entries are ambiguous about whether that's the clerk entering judgment.
I'm looking at this October 17th judgment.
Yes.
And it doesn't say your complaint's dismissed. It just says you have to pay $12,840.57. And your notice of appeal seemed to only appeal this judgment. So how does that notice of appeal the dismissal of the case?
Well, as I read it, it says judgment entered this date. I mean, that's the first part of that entry. And the judgment is the judgment on the motion for summary judgment that was allowed.
Well, no, it doesn't say that. It says, after judicial finding is ordered and judged, the judgment enters outlined below, and that judgment is to pay $12,840. It doesn't say anything about the complaint at all.
Well, those were the costs, right. I mean, the defendants didn't have a claim for any kind of money damages or anything. The award to them was judgment dismissing the appeal, judgment dismissing the claims, and this was the award of costs. But I guess that's the ambiguity, because as I read that, that's the final judgment on the plaintiff's claim being dismissed and the defendants being awarded costs. The judgment being entered by the court clerk.
Looking at the docket, you tried to draw a distinction, I think, between something being entered by the judge and something being entered by the clerk. And I think your point was that unless and until it's entered by the clerk, it's not entered for purposes of our rules of appellate procedure. That's your argument?
That's my understanding, Judge.
Right. So I'm looking at the docket. I'm looking at page 9 of the record appendix, entry for pleading 28. This is on the docket. I assume it's a fair inference that clerks, not judges, make these entries on the docket. And it says 725, summary judgment for defendants, down at the bottom, entered. Copies mailed, 7/25/24. To me, that is clearly a clerk entering the summary judgment, dismissing, above that, the plaintiff's complaint be and hereby is dismissed. Entered and copies mailed, 7/25/24. To me, there's nothing ambiguous or unclear about that. To me, that is very clearly the end of the case, and you have 30 days from that date. What am I missing?
Well, Judge, I can tell you that's not how we read it. I read it as that's entering the court's order on the docket. And, it clearly did not have the same kind of entry that we get in October, where, the October entry, it starts right off. Judgment entered on this date, which is essentially what we were expecting to see. We saw that earlier entry, and I looked at it. It did use the word entered. We looked at it and concluded that that isn't the entry of judgment by the clerk. It was just entering the judge's order and the previous allowance of the motion.
But sorry, so if I go to the addendum, or page 51 of your brief, I see you said we didn't get anything like what I just read from the docket. But now I'm looking at the thing, summary, this is the page that was mailed, entered and copies mailed, 7/25/24, the actual physical document that was mailed to the parties. Summary judgment, Mass Rule Civil Procedure 56, date judgment entered, 7/25/24, the plaintiff's complaint be and hereby is dismissed. So I assume you're not disputing that you got this in the mail.
I don't dispute that we got it. We did get it.
Right, and so you got it in a timely manner. So you did get this document, and this document, again, to me seems completely unambiguous, that this was the date from which you need to start counting 30 days.
Judge, all I can say in response to that was when we looked at the docket sheet in that paper, we did not read it as entry of the judgment by the clerk.
Okay, and then there was
ambiguous to us, and it.
Right, so there was a motion, right, there was a motion.
Compare it to the other entry, it is.
Right, and so.
More ambiguous than the October entry.
Do you have any case law to support your proposition that you're entitled to the extension of the to late file your notice of appeal? I couldn't find any case law that I thought was analogous for this sort of error.
I don't have any analogous case law. That's correct. You did not find that either.
Okay.
We did cite to a text, but that was the only material we found.
The notice or document that you got in October of 2024, the reason why it's in that format is because there was money involved, and it had to show amounts and taxes and prejudgment interest, etc. What did you expect in a normal case you would get in the July order? Just something that says judgment entered? Like, I'm trying to help to figure out what you think you should have gotten from the clerk's office.
Judge, that's what I expected the entry was going to say. Judgment entered this date, just as it did in October. I mean, I can't say any more than that, Judge. We did see it. We looked at it. We saw the word entry. It gave us pause, but when we looked at it more, it appeared to be just the entry of the orders and not the entry of judgment by the clerk.
Why don't we move on?
So on the merits, there seems to be a principle, and please correct me if I get this wrong, that insurance agents shouldn't be held responsible for figuring out the amount of need that a party has unless there's a special relationship, right? Did I get that principle broadly correct?
In the abstract, that's correct.
And your
yes.
argument is that this was a
It's not
special...
their ordinary duty to advise as to coverage.
And
Correct.
here there was a special relationship because it was the brother and brother-in-law who was the insurance agent, right?
Our argument is there was a special relationship, but our primary argument was, regardless of whether they had a duty to advise the plaintiffs about their coverage, they did advise the plaintiffs. And they misadvised the plaintiffs. They gave them advice that was
Right, you
false.
keep saying, yeah, and so that's a great place to start. I never understood that. So I'm going to characterize it the way I heard it, and you correct me if I get the characterization wrong. But they have this conversation, I think it's in 1992, but to grossly oversimplify, they're talking about your underinsurance coverage and your health insurance. And they say, you've got $100,000 of underinsurance is enough because you have good health insurance.
Correct.
And your characterization of that is that was false or misleading because health insurance didn't cover pain and suffering. But if that's a fair characterization, and correct me if I'm wrong, I disagree with that. My reading of that is if you've got that, he's giving advice. In his opinion, if you can have health insurance that'll cover all the medicals, because it's good health insurance, and then if you have the $100,000, which is way above the mandatory minimum for underinsurance, that'll cover pain and suffering and lost future earnings. That's an opinion, and that's a reasonable opinion. Where's that wrong?
Well, it's wrong in the sense that what the plaintiffs expected they were purchasing was increased insurance that would match their bodily injury and underinsured motorists. That's what they had previously.
Wait, so thought they were purchasing from who?
The plaintiffs.
No, the plaintiffs thought they were purchasing from who?
From the defendants.
Oh, okay.
They had policies with the defendants prior to getting the umbrella
They
coverage.
were purchasing. They were purchasing $100,000 under insurance in 1992. In 1992, they did purchase $100,000 under insurance.
That's right. They
Right,
had
so you said they thought they were purchasing. They were purchasing that.
They initially had an auto policy that had $100,000
Right.
coverage for bodily injury
Right.
and for uninsured, underinsured motorist coverage.
Right.
They then wanted to get an umbrella policy. They talked to the defendants. They decided they were getting an umbrella policy. They needed more coverage. They expected they were getting more coverage, and what they expected was that the new coverage would be the same for bodily injury and underinsured motorists. And when they got the policies, they didn't just ignore them, they actually looked at them, and they saw two things. They had a new auto policy, which had increased bodily injury limits, but not increased underinsured motorists.
Still 100,000.
Underinsured was still 100, and the bodily injury was 250.
Right.
And then on top of that, they had the umbrella, which included $1 million bodily injury, but no underinsured motorist coverage. And that's when they asked. Well,
No additional underinsurance coverage. They had $100,000 underinsurance coverage.
they still had $100,000 in the auto policy, that's correct. But their question to the defendants was, why don't we have matching coverage now? Why don't we have more underinsured motorist coverage? And that's when they're advised, you don't need it.
So here's what I don't get. You've briefed, especially the expert opinion issue, as if your claim was for negligent misrepresentation. But I didn't see anywhere in your complaint or your summary judgment opposition in the Superior Court where you raised the tort of negligent misrepresentation. Am I missing it?
I think we raised the question of negligent misrepresentation right from the beginning. I mean, that was the factual underpinning of the plaintiff's claim. they had received false and misleading advice from the defendants. That was always the claim, and that amounts
Well, the
to...
complaint says he had a duty to properly advise them, and he failed to advise the plaintiffs as to the type and amount of coverage they should have. It doesn't say there was a negligent misrepresentation, and I didn't see that in your summary judgment opposition either.
Well, I'm not sure that, maybe we didn't phrase it using those words, but clearly we argued that was our primary claim before we ever get to the question of special circumstances and whether defendants had an independent duty to advise them. The very first argument we made was that defendants did advise them and that the advice they gave was false and misleading. However you want to characterize that, I mean, we characterized it as advice that was false and misleading. But clearly that's negligent misrepresentation.
Do you want to tell me where you put that in your summary judgment opposition? Because I don't see
I
that.
believe it's right at the beginning of the summary judgment opposition. I don't have it right in front of me, but
It says the ordinary duty is that an insurance agent has no general duty to ensure that insurance policies, well, that's obviously not what you're saying. All right.
And it did come up specifically during the summary judgment hearing, where the judge asked whether that was what we were claiming.
Can you just, what was the,
Misrepresentation. And my answer to that was yes, that's exactly what we were claiming.
and this factually, it's this conversation where he says, you're under insurance plus your good health insurance is enough, right? That's the moment where he allegedly makes a false representation.
Right. Then
right?
that's in response to the question is, why didn't we get the matching coverage?
Yeah, and what year is that?
I'm sorry?
What's the year of that conversation?
I'm not certain exactly. We couldn't get policies going back that far. It was in the 90s.
In the 90s?
Yes.
Okay.
The plaintiffs were married in the early 90s, and it was several years
Right.
later that they
Right.
got the umbrella.
Yeah, okay, thank you.
And then again, I mean, that wasn't the only misrepresentation. In 2012, the plaintiff's oldest son got his driver's license. They were going to add him to the policy, and so there's a discussion about doing that, at which time defendants advised them.
We're going to have to, your time's up. We're going to have to leave it there unless there's further questions.
Okay, thank you.
All right. Thank you, Counselor. And we'll hear from the insurance agency.
Good morning, Your Honors. Louis J. Muggio for the appellees. On the issue of timeliness, it's clear that this is not an appeal from the motion for taxation of costs. It's an appeal of the summary judgment ruling. And as Justice Wood noted, judgment entered on the docket by the clerk on July 25. That is not in dispute. There has been no showing whatsoever of excusable neglect. I believe in the briefing papers it suggested that they misunderstood the docket entry. So the appeal is untimely. There's no excusable neglect, but I will address the merits of the case.
But he's at the very least, they've got a timely appeal of the costs, right?
That's not articulated, and in my briefing, it's clear that what they are appealing is the summary judgment decision.
Well, what they've briefed is that, but there's a timely appeal of the costs, regardless of whether they briefed it, right?
Which none of us have briefed, Your Honor.
Yeah, but you moved to dismiss, and I'm not sure dismissal makes sense in this circumstance where there is a timely appeal of something.
Well, they are appealing and argued the summary judgment decision there, but I agree with Your Honor. If there is any act of appeal, it's only on the motion for taxation of costs. On some of the preliminary documents, I believe the docketing statement, I referenced that in my initial motion, they articulated that they are appealing the summary judgment decision, not the motion taxation, but they wrongly used that October entry date to start the 30-day period. I want to follow up on something that Justice Wood articulated, and the law in Massachusetts is clear that an insurance agent, such as my clients, have no general or affirmative duty whatsoever to advise an insured as to the scope and adequacy of coverage. That has been Hornbook law in the Commonwealth for decades.
I agree that that's the law, but when they do undertake to do that, what is does there become a duty at that point? They have no duty. I agree with you under the case law to advise. But if they open their mouths and do so advise, what happens then if there's a misrepresentation? I'm not saying there was, but let's assume.
Well, in oral argument here and at the summary judgment hearing, counsel argued there were misrepresentations, that my clients engaged in fraud and deceit, made false statements. It's clear the complaint is a professional negligence complaint. It's not a fraud and deceit complaint. It's not a complaint predicated on misrepresentations. So we've got a 6-count complaint. There's only one count, count 1, that deals with the issue of professional negligence. The other 5 counts are derivative. There's consortium claims and 93A claims. And to answer Justice Wood's question, the plaintiff's claims are predicated upon a statement that Glenn Nickerson allegedly made in 1992, that they do not need higher underinsured limits. What's interesting is at the time, the minimal limits were 2040. The agency advised them to increase those minimal limits to $100,000 for a period of 25 years. The plaintiffs received renewal applications. They received documentation from the Commissioner of Insurance explaining what underinsured coverage was. For 25 years, they kept that coverage and never questioned the agency as to whether that should be higher. Now, a large issue in this case is what is adequate coverage? Their complaint alleges, well, we received improper advice as to what we describe as inadequate coverage. What a fatal flaw in the case is they allege inadequate coverage, but they don't tell us what is adequate. There's nothing in the record to say that they should have had $250,000, $500,000, or $1 million in coverage. Just stating the coverage is inadequate is a claim in a vacuum.
Can I ask you a question?
Yes.
So there's a piece of this is very interesting to me. In 2007 to 2009, in that time frame, their health insurance situation changes dramatically. And it's a little fuzzy from the deposition transcript, and the father of the child doesn't quite articulate it clearly, but it seems that they're getting some sort of Medicaid insurance. And fast forward to the Geico moment. It's also clear that in that deposition, at that moment, the father says, under sharp, clear questioning, did you tell Glenn, did you tell the defendant about this change in insurance coverage? No, we did not tell Glenn about this change in insurance coverage. Okay, right. So fast forward to 2013 when they are late 2012, we're going to go to, Glenn advises them, go to Geico because Geico's cheaper. Is there any factual basis for, well, at any point between those two markers, the defendant, the plaintiffs telling the defendant that they'd had this dramatic change in health insurance? And the reason I ask, I'm not trying to hide the ball, is because it seems that if he's got a special relationship with them, and maybe under Martin Onis, maybe he does, you didn't distinguish that case in your briefing, then maybe he has an obligation to give them some affirmative advice that now this is not adequate. I don't know. That's the idea. But there's a factual question there. Did he know? Is there any evidence in the record that he knew that they had a dramatic change in health insurance coverage?
There's no correlation between health insurance and coverage. They're different coverages. So even if that's a fact, it's not a material fact.
I don't see why that's so. If you've got really good health insurance, then you wouldn't need as much coverage for your medical expenses. if you get hit by an uninsured motorist.
Yes, that's what I was getting at.
Getting back to 2013, it's our position that, to begin with, there's no general duty. That duty, however, becomes more attenuated after the plaintiff switched to GEICO. The record's clear that GEICO has a direct right. The plaintiff's, Elizabeth, communicated on a regular basis with GEICO. The record establishes she made changes to the GEICO policies.
Right, but hold on. What's more interesting to me is their allegation, which I'm pretty sure you guys dispute, but we're at summary judgment phase, so it doesn't matter that you dispute it. Their allegation that there's a conversation in that switch to GEICO where her brother, the defendant, says, right, go to GEICO because it's cheaper, right? We can't match that, but show me their policies every year. I'll make sure that you have enough coverage. That's what she alleges he said. I know that he's disputing that he ever said that. I get it, but it's summary judgment. So that seems to me to be the thing that we need to focus on. Does he have a special relationship with her, and does that create some sort of...
As the motion judge correctly found, once they switched to GEICO, the professional relationship with the agency regarding motor vehicle coverage terminated. So again, we have no duty to begin with. The duty that becomes further attenuated. Important issue. What's enough? What's adequate?
But if you're issuing an umbrella policy,
I'm sorry?
if you're issuing an umbrella policy, you need to know what's outside the umbrella. I mean, that's why you got to know what the auto insurance is, because the umbrella has to
You need to know,
kick in at a certain level, and you don't want an umbrella if someone isn't insured generally.
with all due respect, the amount of coverage, automobile coverage, has no correlation to the amount of the umbrella. What the umbrella requires is an underlying bodily injury policy.
Right.
So there's no nexus. I want to touch, if I have plenty of time, on the lack of an expert. As we all know, having done this for many years, insurance industry is complex. Agents, like lawyers, are licensed, and they have a very specialized skill. Although this is a professional negligence case, there's nothing in the record whatsoever to establish what the standard of care was with regard to the agency's duties. The claim is inadequate coverage. That's the claim. But there is nothing whatsoever in the record, either from the plaintiff or an expert, to say what was adequate. There's nothing.
I take your point. I think that makes sense. Going to your brief at page 33 of your brief, you note, plaintiffs alternatively argue that no expert opinion on the standard of care is required, and that they expected, that's the first part that you're disagreeing with, I get it, and that they expected to present such expert testimony as part of the pretrial memorandum. Their defense is broadly, this was premature. We didn't have a chance to go and get our expert. We would have gotten an expert if you made us get an expert. But you didn't then respond to that argument in your brief.
Well, they could have filed a motion under 56F to get additional time. They didn't. And it's a professional, when we undertake and look at a professional medical case or a legal malpractice case, the first thing we do is we secure an expert opinion. Here they put the cart before the horse. First of all, they didn't realize there's no general duty, and then they make this unfounded allegation that coverage is inadequate. How is a jury or this court or any other court to determine adequacy? It's a contention in a vacuum. So without that underlying expert opinion establishing the standard of care of these professionals, as the motion judge found, the complaint fails as a matter of law. The plaintiffs argue, well, it's common knowledge. It's not common knowledge as to what is adequate. This is not a case where The plaintiffs paid a premium to the agent, and the agent failed to bind coverage. It's like in a legal malpractice case. If the lawyer misses a statute of limitations or misappropriates funds, perhaps you don't need an expert. Here we have a very complex issue as to adequate coverage. And without an expert opinion establishing the standard of care and a breach of the standard of care, their complaint fails as a matter of law. With regard to the other 5 counts, I suggest that those are derivative. If the judgment is affirmed, those claims also fail. Thank you.
All right. Thank you, Counselor. Thank you both. We'll take it under advisement. We are going to have a break now for about 15 minutes, and then we'll come back for the last 2 cases.
All rise, please. Court is now in recess. Court is now in session. Please be seated.
All right, we are back in session. I'll call our fourth case, number 24P 1326, GIOMBETTI versus PAECHT. Is that right?
PAECHT, yes.
PAECHT. All right. Counselor, whenever you're ready.
May it please the court, Isaac Perez for the appellant defendant Stephen PAECHT. As you know, we're appealing a decision by Judge Moriarty from the fiduciary litigation session. And in that decision, Judge Moriarty ruled that my client, Mr. PAECHT, had waived on two different occasions a right to purchase his deceased father's property up in New Hampshire. And I guess I'll address the first instance of a waiver first. The party's father passed away October 30th, 2021. About roughly a month later, the two sisters and the brother got together with a law firm and they said, well, you know what, let's put the issue of disposing of the property off until the spring.
Okay, let me get right to that issue.
Yep.
The document, the trust document says that the offer to buy has to be made within 45 days of the decedent's death. Do you have any legal support that the beneficiaries of a trust instrument, which the children were in this case, can extend that time frame by agreement, if that's what the trust document says?
It says that once made, it shall remain open. You have to have the physical act of somebody sending the letter.
Where does it say that?
Appraisals.
Where does the trust say that?
No, let me get to the language. It says, said real estate shall be offered in writing to the donor's children at a value equal to 95% of the average of the two fair market value appraisals obtained by the trustee.
Right, and the offer shall be valid for a period of 45 days following the donor's death.
Correct, but if the offer has to be made first. I get it that the...
Doesn't that make following the decedent's death irrelevant if we read it your way? Because the way you're reading it, it stays open, I don't know, forever until an offer is made.
Well, it's up to the parties, obviously, to effectuate something like this. I mean, it doesn't happen automatically. So they made a decision that they didn't want to deal with it.
Right, but that they includes your client.
It includes
Your
my
client, as a trustee, decided not to make the offer that the trust requires, that
no.
expired 45 days after the death.
His position is, and I agree, is how do you know what the price is? You can't just say, well, I want to buy something.
We know how to find out what the price is. It told us right in the document. He goes out as a trustee and gets two appraisals. But he chose not to do that. That's how he finds out.
He chose not to do that, but ultimately, when you see how this played out in reality, the law firm went out and got the appraisals.
So that's the thing that really confuses me.
Yep.
Why can't the sisters buy it for $513?
They can, and they had an opportunity to do it.
And
they were sent the letter in May of 2022.
Right, and they've already
they declined.
And they've already offered $600. So if they're willing to pay $600 and your client's willing to pay $513, why does your client get it and they don't?
They don't get it for what, $600 or for $513?
I mean, either.
Yeah, I mean,
I don't understand. So if they're plainly willing to pay at least $513 for the property, it even says in the later offer letter that they're reserving the right to pay it. So if your client's willing to pay $513, doesn't it get bid up? Doesn't it go to the child who is willing to pay the most?
well, the problem is that this clause doesn't address that. There's a lot of things that this clause, I think, is deficient. Yeah, what if a letter is sent out and all three want to exercise the right?
But there's no if. We know the sisters want to pay $600 for it. So why isn't that the end of the 513? If all the children want to buy and two of them are willing to pay $600 and one's only willing to pay $513, why don't the children want to pay $600
Well, because
win?
it says here that he has the right to buy.
Yes, but so do they.
Okay.
So do the sisters.
Correct.
So what do you think happens when all three, which is the case, want to buy it? What do you think happens then?
It probably gets sold to a third party at that point who's willing to pay more, or
But isn't that what the judge ordered?
that is what the judge ordered, but also the judge shut out his opportunity to buy it for $513. He was ready.
I don't understand. You just said that if all the children are willing to buy it, which is the case, that then it should be sold in open market to someone, which is what the judge ordered. So why isn't that all correct? That's just what you said should happen, and it's what happened.
Well, again, I think that sort of subverts the point of this, which is that someone should be allowed to buy it for $513 if they assert their right to do so.
I think maybe
And they do it in a
that's a
timely
pretty good
fashion.
argument. I mean, build that out a little bit. Like, I think that one of the intent, we're supposed to honor the intent of the donor, the father here. And clearly the second clause seems to be, part of his intent is, it seems, I want to give my kids a chance to buy this under market value, right? But then, and you sort of said this quickly, but his trust document didn't conceptualize every possibility. He clearly had this idea that one of them would want to buy it, but what if more than one of them wants to buy it? That's the Justice Ditkoff's point. So, it's not just the market, and then it goes to the market. No, I mean, I think there's an argument that no, there's this idea that he wants to let a kid have it, which is an understandable thing, to under market. Okay, so how do we keep it under market but have a bidding war? That seems really complicated.
Yeah, no, it's problematic. I agree with you.
Right. Okay, but can we go back?
But that's not what
to
happened.
the original waiver?
Yeah.
Because you didn't really. It seemed that my point was we know how to figure out the price he's supposed to pay. Your client said, I don't know what price to pay. That's not right. You do know how to figure out what price to pay. You go and get 2 appraisals, and you're a trustee, and he could have done that. And so he didn't do that. And it seems to me what I'm getting at is that decision that the three of them make to wait until the spring, to me, is completely disconnected from his decision not to go out and get 2 appraisals and figure out how much it was worth or how much he would have to pay. So why is the waiver, at that first waiver, not the end of the matter?
He testified repeatedly that he was waiting for the letter to come to him.
But he's the one who's supposed to send the letter. He's a trustee. I don't understand how he can wait when he's a trustee.
Right. It's really all 3 of them, though. It's not just him. It's her. It's all 3 of them.
Is he not allowed to go out as a trustee and get 2 appraisals?
He could have. I
Right.
think in theory, sure, he could have.
Right.
But on the other hand, they hired a law firm. And I think my client was relying on the law firm. Actually, he also hired his own lawyer because there was a lot of distrust between the parties. But that's the way it played out. The law firm did the work. The law firm went out and got the appraisals. It shouldn't be placed solely on him. The sisters then have a duty to do it too. They didn't do anything. Did they go get appraisals?
So
No.
it shouldn't be placed solely on him to go and get an appraisal.
No.
If he wants to buy it, he's saying my problem is I want to buy it. My problem is I don't know how much to pay. The trust document tells him as a trustee how to get the answer to that. What's the problem that his co-trustees have to help him? They don't have to help him. He's creating a problem, it seems to me, that out of nothing. It seems to me that it's his fault that he doesn't know how much to pay.
It's really the burden is on all 3 of them combined and the trust to send it out, which is exactly what happened in May, in the spring.
Well, if it's on all 3 of them, it's on him, right?
What's that?
If it's on all 3 of them, it's on him. It's not like he said, let's get some appraisals, and the other 2 said, no way. He didn't say anything, right?
But he was consistent that he was relying on someone else to do it. He was expecting the trust as an entity to send him the letter. He said that repeatedly during the trial, over and over again. I was waiting to get the letter. His attorney demanded the letter in the spring, and that's how they got it. The law firm undertook the duty, this job of getting the appraisals and then sending out the letter. So, the way I look at it is the sending of the letter and the being able to sell it to a third party, they're intertwined. You can't sell it to a third party until that letter has gone out. The trust is very clear about that. So you can't just say, well, from his point of view, he says, well, we're going to defer everything till the spring, okay? What you're also deferring is the sending of this letter and the getting of the appraisals. And if you look at the way it worked...
Well, the
in
judge,
practice-
that's what your client testified, but the judge found that all three children, what the letter says, agreed to sell the real estate in the spring on the open market.
Yeah, well, they
If your
had...
client agreed to that, isn't that a waiver
But
of
again,
his
you
purchase?
can't sell it out in the open market until you've sent out this letter. That's a prerequisite.
Even if
It has to be.
even if all the beneficiaries agree that that's what they want to do?
If it's stated openly that, hey, I'm not going to buy it, I have no interest in buying it, and the sister says, I have no interest in buying it, okay, good, we'll sell it to a third
No,
party.
no,
That's not what we're
all
saying.
three beneficiaries say, okay, we're going to sell the real estate on the open market in the spring. Why can't they agree to that?
They can, but they've also got to follow through with the other part, which says that it has to be offered to the
So
beneficiaries via letter.
they can't all agree to sell on the open market without getting to appraisals for no reason and showing them to people when they've all agreed that what they're going to do is sell on the open market.
I don't believe that's what was said here. There was no testimony that we specifically discussed the issue of getting the appraisals. They said, you know what, no need to do it. None of...
Well,
confused.
that's what the judge found, and that's what Cynthia testified to. Why couldn't the judge believe Cynthia's testimony?
I don't think that's what I remember of the testimony was that I think one of them, and I believe that was Karen, was in Florida. They also agreed that it was tough to get into the property during the winter months. Theoretically, it might even be difficult to get appraisals if you can't get onto the property. And that's why they decided to postpone it, because it's a pain in the neck to get to that remote property in the wintertime.
And so when you say you were going to list it, you mean list it with a broker, yes. And it was your intention to place in the open market for some open market right. Why can't the judge believe that?
When you say your intention, you're talking about Cynthia?
Well, the judge, his testimony, this is what you guys discussed, conversation with your brother and sister on 114. Oh, so, well, I guess, so you think that's, are there any other,
I don't think that's
are there any
clear.
are there any other findings that the judge made that you think are clear?
Yes.
Could you tell us what they
There's
are?
the second finding of a waiver, which occurred after the letter, the option letter was sent out in May of '22.
No, what factual findings of the judge are clear? Are you telling me that you think that all three children agreed to sell the real estate and the open market's a clear error, right?
No, it's not, it doesn't constitute a waiver.
No. I'm asking you what factual findings the judge made are clear error.
I'm sorry, what?
The judge made a bunch of factual findings. I'm talking about the legal conclusions. Which factual findings the judge made are clear error?
I think it's not that so much as the legal conclusion of the waiver is what I'm challenging, that the facts that she found don't amount to a clear, unequivocal conduct, decisive conduct by my client that constitutes a waiver. And that's on the initial waiver. On the second waiver, the letter went out, okay?
So I don't know why you keep calling that a waiver. It just expired.
Calling what waiver?
Why are you calling that waiver? It just expired. There was an option to buy for a certain amount of time, and that time ran.
That's how the judge characterized it that way, and said by not responding by July 9th or whatever the drop dead date was, he waived the right.
Not waived, just missed the deadline.
Okay, missed the deadline. But how can you wait, how can you,
Missed a deadline you don't know about? That happens.
you don't know
that-
about because you
That
didn't.
that happened earlier today in
you
one of
don't
our
have-
cases.
You don't have actual knowledge. It got, the attorney to whom it was mailed, first of all, it was mailed to the wrong address. Okay, they mailed it to Braintree. The guy practices in Attleboro, so he never
Right,
got
but, sorry,
the letter.
how much, you know what I'm going to ask. It's sent by email as well, and he's gotten emails before. Let's say that we disagree that his lawyer didn't get this by email, and/or we reject his claim that this one went to spam and therefore, because he did get it. He doesn't even he doesn't dispute that he got it. He says I got it, it went to my
saw it.
spam folder. Let's say that we reject that claim. What does that do to your claim on that second point. That, okay, now you have the two offers, your lawyer has them, you've said, I'll go through my lawyer, okay, your lawyer has them, still no written offer for 45 days.
Yeah, then he's in trouble. I mean, I'm not going to
Okay.
tell you.
Okay.
But I just think that it's not fair to say to someone, you didn't respond to something that you never physically laid eyes on. And it's as much their fault. I mean, why didn't they use certified mail? That's what people do, and send it to the correct address.
Well,
That's
people,
what people do.
we have notice provisions when we've got lawyers involved about what's adequate notice, and there was nothing here. And also, the parties had been communicating by email back and forth.
Yeah, but problems happen and stuff goes to spam folders. I've had it happen to me. And he came right back and said, wait a second, guys, I never saw this. Now that I've seen it, give me another 45 days. And they told him to forget about it. And that comes to my last point. Ms. Tomasetti openly admitted to me that she, during cross-examination, she would never allow him to exercise that option. There's a lot of bad blood between them. And I was actually fairly shocked that she said to me, there was no circumstances under which he was going to get that property for 513.
That's not what she said.
Yeah,
She said, I'm not going to just say, yeah, you can have it for 513, which of course, since she's willing to pay more than that,
well, but that's
has
not
to
the
be her
reason
position.
She attributed it to it. She said it's because he had cheated me in the past, and we had these problems in the
I want all of us to get what we're supposed to get.
Yeah, but
I'm going to tell you that if that happens, I want to buy it then. Never mind. I was going to ask what's bad faith about that, but
No, she was very clear why she didn't want to let him get it for 513. It's because he had made out in a settlement, according to her, she felt cheated, and she said it's not going to happen again. I'm not going to get cheated again by him, so
Yeah.
that he gets the property at a reasonable price, lower than what I think he ought to pay for it. So, she's asking for equitable relief.
all right, we're over time, and a lot of that's my fault.
It's okay. I've made my points. Thank you.
Thank you, counsel. In fact, it's entirely my fault. We went over time. Entirely.
Good morning, Justices. My name is Christopher Mingase, and I'm representing the appellees of this case. I want to start by saying that Judge Moriarty was very intent at trial. She listened intently. She was engaged. She asked questions of the witnesses. She clarified any misunderstandings that have been conveyed by some of the witnesses. I felt that her decision was well written. It was an 8-page, single-spaced decision, and I think it supports her findings. And I would ask that this court adopt those findings and deny this appeal. I'm happy to answer any questions the court has or give you a short argument if the court prefers.
If you're content with your briefing, that's up to you.
Then I am content as well.
All right.
Thank you.
Now I don't feel so bad about going over. All right, thank you. Thank you both, counselors. All right, so our last case for the day is 24P1056, adoption of children. I know we got quite a few people, 5 different people arguing, so if everyone could just come up. We're definitely going to need to pull one of those chairs over. And Councilor O'Brien, if you want to pull up a seat too, I know you're not arguing, to be near your client, I think that's probably a good idea. We got, that's all the seats we have, but we have that many. All right, let's make sure everyone's situated. And I know we're going to start with Attorney Anoff. Whenever you're ready, Counselor.
Good morning, Your Honor. My name is Warren Yanoff, and I represent the father, J.P., who is the father of the youngest child.
Oh, I'm sorry. Can you stop the clock a second? But just reset it up to 5. I got distracted. I should remind everyone, this is an impounded case, so we're not going to use any names of the children or the parents. We're going to say mother, father 1, father 2, or father of the boy, father of the girl, boy, girl. We're not going to say any of the names. This is being live streamed, and we don't need their names to be out there on YouTube. I'm sorry, I should have said that before we started. We're going to start over again. Counselor, when you're ready.
Before I start, I'm not sure if I am father 1 or father 2. That's why I used the
Father
initial.
2.
Father 2.
Okay.
Father, yes, younger child.
Thank you, Your Honor. My name is Warren Yanoff, and I represent father 2, who is the father of the youngest child. Both children have the same initial. The issue for my client is post-adoption visitation, assuming that this is going to go to adoption. The issue is, what does best interest mean for post-adoption visits? I would suggest that the case law is really very silent on the issue. It talks about stability, it talks about whether the placement is good, is the child doing well. It really doesn't focus on the emotional health of the child and the need for post-contact with the biological parent. As a matter of fact, the expert in this case indicated that maintaining a relationship with the biological parent is healthy. The judge in this case made literally no findings regarding best interest as to whether post-adoption visits would be in my client's best interest.
Well, the case law regarding adoption talks about bonds between child and parent. And the judge did state that there was no evidence of any emotional bond between father and the daughter. Isn't that enough?
No.
Tell us why.
Because, as I point out in the brief, the research shows that contact, even with an absentee parent, once happened, is important to establish the child's identity. As I say, their expert indicated that contact was important. This is something that is not addressed at all in the judge's finding. My client is not claiming that he is a fit parent. However, when we say that post-adoption visits or anything is for the benefit of the child, it needs to be explored. And with all due respect to the case law, they don't ever really address the fact that it's a benefit on the emotional, especially as a child gets older. It talks about.
I agree. I mean, to the extent I'm allowed to and not follow precedent, I think that's a great point, that the psychological benefit of knowing your parent, no matter what your parent's history is, I get it. But that is in the best interest of the child, it seems to me, unavoidably, even if we agree that that's a positive, there's unavoidably in the best interest of the child a weighing that we have to be trying to figure out, or that the judge has to try and figure out. And the judge is also, I think, allowed to consider the fact that the father here fled in April of 2022 and then was incarcerated and therefore had no more visits up until the date of trial. Isn't that important?
Obviously, things are important, but what we also have to understand is when he did have visits for that period and he was visiting, those visits went well. At the end of this, the DCF was willing to do virtual visits while he was incarcerated. They produced a post-adoption agreement that he was willing to do. That was on my motion to reopen it on this issue. And the only reason that that was not allowed is because the pre-adoptive parents said they wouldn't agree to that. So to that extent, that was addressed in the sense that he was not totally absent.
Isn't
there
the
was-
case law, I think it's the, and correct me if I'm wrong, the case law indicates that the pre-adoptive, ultimately adoptive parents become the parents. It's appropriate for a judge to delegate to them what is in the best interest of the child on these, the judge doesn't have to, as in this case didn't, but with the other parents, but it is permitted to delegate that choice to the parents,
But
the
I
new
think
parents.
If we're going to do that, we still need to look at what is in the child's best interest. We can't presume that just because the pre-adopts maybe have nurtured this child and done well, that taking into effect, with all due regard, the emotional aspect and the need for that. And I feel that the case law is deficient in addressing that issue. And so I would ask that this court remand it on that simple issue because it was never explored and it has a benefit to the child.
All right. Thank you, Counselor.
Thank you.
We'll hear from Father One now. Whenever you're ready, sir.
Good morning, sir. If it so pleases the court, my name is Melvin Punch. I wish to thank the court for allowing me this time to speak this morning. This makes a second attempt to appeal the termination of my parental rights before the appeals court. My first attempt for my firstborn son in 2018 ended in failure. The appeal denied. I was not allowed to any further appeals in that case because the Bar Association denied me funding to do so. I am appealing to the court today the trial court's termination of my parental rights to my second son. Both sons were removed from my custody from the hospital at birth. I understand that this court is here to determine if I am unfit to parent my son by clear and convincing evidence, and if the trial court's determination to terminate my parental rights to my son are in his best interest. I would like to state that the trial judge for this case did not give a fair and unbiased evaluation of all the evidence presented to him. Throughout the course of the trial judge repeatedly dismissed my testimony as untruthful. In particular, my relationship with my two sons' mother. In this case, at trial, I stated that I was my son's mother's representative payee for her Social Security benefits. This fact was not disputed by the court, but the fact that I have held that position for nearly 10 years goes towards establishing that my relationship with the mother required me to have contact with her. The trial court ruled that my contact with the mother represented a risk of harm to my son and thus rendered me unfit. That is blatantly false. The trial court used primarily third-party police reports to create a narrative that depicted an abusive relationship existed between myself and my son's mother when my son was conceived. The trial court then went on to introduce into evidence the DCF narrative that the relationship between myself and the mother continued for years after it had already ended. They did this in order to remove 2 additional children from her care. My association with my son's mother was depicted as rendering me unfit to raise my son. The trial court determined the mother to be unfit, so by association, I was unfit. That is biased and prejudicial to my case and prevented me from receiving a fair trial. The trial court used codes, rules, and regulations to remove 2 sons from my care in 2 separate trials. Respectfully, I would like to state that I and my 2 sons are not bound by institutions formed by my fellow man without consent, that I am independent of those laws that are not defined by God and nature. This fact is supported by the Supreme Court decision of Rodriguez versus Donovan. In this case, I never entered into a contract with the Department of Children and Families. I realized from my first trial in family court that DCF's attempts to force me to comply with services was never intended to reunite me with my sons. I completed parenting classes, multiple fathers groups, domestic violence classes, ad care, as well as counseling sessions at the VA. Yet every task completed, I was still found to be non-compliant. It is my belief that the trial court in this matter did not operate as a court of conscience. In my 2 cases before the court, the trial court acted as a court of commerce, no disrespect intended. The reason being, the termination of the rights to my sons was the court extracting federal funding under Title 4E for the state. This was done in direct violation of my constitutionally protected rights. In Cooper versus ARUN 358 U.S. .1 785, it states that no state legislature or executive or judicial officer can war against the Constitution without violating his undertaking to support it. The trial court allowed me to be portrayed as unfit based almost entirely upon his testimony that I am unfit, my association with my son's mother, and this presumption I did not receive anything to prove I was not unfit through their services. The court gave no consideration to the fact I served 4 years and was honorably discharged, no consideration to the fact that I raised 2 daughters to adulthood who both graduated from 4-year universities and owned their own homes, no mentioning of me working as a New York City Corrections Officer for 3 years and retiring 21 years disabled from the U.S. Postal Service. No mention that I own 2 properties, both for over 20 years, and I converted one of my properties into a nonprofit, 501c3 nonprofit charitable organization, registered in the state of Massachusetts. The trial court's decision and DCF concerns are primarily based upon unsubstantiated third-party police reports. This is not justice. It is unlawfully removing children and a gross violation of every citizen's rights. My son's mother gave birth to her 10th child. That child has been in her care since his birth. This disproves the court's determination that she is permanently unfit to ever care for a child, and thus that by association with her, I am unfit. I am fit, competent, and ready, willing, and able to raise my son.
All right, sir, I have a question. So I understand you're raising whether there was enough evidence of your unfitness. I get that. And that one of your primary arguments is that the judge was relying on unreliable and hearsay evidence. And you're also questioning the effectiveness of your counsel.
Yes.
Is there anything else, are there any other major arguments I'm missing? Well, and the legality of your contracting with DC, your legality of the...
Of the removal, jurisdiction.
Yeah.
Jurisdictional issues as well.
Jurisdictional.
And, yes, sir.
Is there anything, am I missing anything? I want to make sure.
No, sir, you've got it pretty much covered. Thank you.
All right, great, thank you.
Have a good day, sir.
All right, so now we have counsel for the mother.
Good morning, Your Honors, and may it please the court. My mother is present in court today with her infant son, who so far has been an exemplary member of the gallery, but if she needs to step out, that is why. Today, with my short time, I would like to focus on the judge's behavior, comments, and demeanor towards mother throughout the trial and the way that this conduct infected the proceedings. The judge's comments from the bench during trial towards mother at times were intimidating, demeaning, and adversary. The judge stated, quote, "Quite frankly, I'm not sure I believe a word that's coming out of her mouth." And when mother tried to explain that the DCF worker, in her experience, was not always entirely credible, the judge stated to her, "We'll see if you can prove it." These statements, just on the transcript, without listening to the tone of voice of the judge, I believe are clear on their face in terms of being structural error. And that comes from well-established precedent, Preston versus Peck, where the judge, quote, made statements to the effect that he had made up his mind and was going to believe a certain witness, and no expert could change the judge's opinion, which made the introduction of further testimony.
Counsel, does structural error apply in a non-criminal case?
I believe it does, Your Honor.
Do you have a case that says that? I really don't know the answer to that.
Sorry, what was
I really don't know the answer either way. Is there a case that says that you can have structural error outside the criminal context?
I believe, Your Honor, that despite the fact that the language itself is not directly analogous with in-care and protection, that, you know, in a couple of instances the case law has run parallel with in-care and protection as it has to criminal law. And an example of that is the substantial miscarriage of justice standard, which this court did adopt in adoption of Vince. And I just bring that up to say...
This court specifically held that substantial risk of miscarriage of justice does not apply in DCF cases, in Doretta, adoption of Doretta.
That is correct, Your Honor, and I believe that the precedent beyond Doretta, so we have adoption of Vince saying one thing, of course, adoption of Doretta saying another, and then we also have a history within care and protection law of another standard, and that's coming out of adoption of Mary and Care and Protection of Stephen, both acknowledging that in exceptional circumstances, there may be room for this court to review unpreserved errors and structural errors that go to the fairness of the court. I also would point to adoption of Norbert, where we have a review of judicial bias despite the fact that it was not preserved below, and adopting the same view that because of the liberty interest at stake, because of the considerable due process rights of parents, that the court has the authority to act and to intervene when such an injustice such as this has taken place. I also point to adoption of Yanis. In a footnote, the court did cite to the substantial miscarriage of justice standard. So I believe we're in a, if structural error has not yet been applied to care and protection.
Sorry, the last one was Yanis?
Yeah, adoption of Yanis, and that is 78 Mass App Court 1111 and note number 4, footnote 4.
Okay.
And just to briefly point to the case law within care and protection where situations such as this have been identified by the court, we have adoption of Georgia, a 2000 Supreme Judicial Court decision, which was strongly admonished the judge's comments, yet found that the judge's comments read in context show that she was attempting to determine the precise issues in dispute so the trial could proceed without unnecessary delay. And so a benevolent intent is imputed onto the judge. And the same is true in this court's decision in adoption of Tia in 2008. Quote, "We understand that the instinct leading the judge to make the quoted remarks flowed in all likelihood from one or more benevolent sources. I argue that there is no such import of benevolent intent onto the judge's comments here, and just the practicalities of a care and protection trial wherein the judge is the finder of fact."
Counsel, can I ask you about the statements the judge made? You cite to page 121 of the transcript, and that is where the judge made those comments. However, prior to that, there's numerous exhibits that have been entered into evidence. One of the pieces of evidence, I believe, and I don't remember whether it was a 51A or a report, that talks about the hug and the kiss incident. Why is it improper when there's evidence in the case already that a judge asks a witness, well, I have this piece of evidence, and now you're saying this, and you're asking me to disbelieve this piece of evidence? What was inappropriate about that? Maybe if there hadn't been any evidence about it yet, that's one thing.
Absolutely, Your Honor. That was a GAL report, and it was a GAL report not authored by the DCF worker, but by another independent court investigator. And it does quote, okay, maybe that they were seen outside, but it actually uses an inconsistent date from the date that's being cited in the transcript during that exchange, which is the date in the GAL report is the 18th of February. The date that they're talking about in the transcript is the 6th of February. And it's not a firsthand account. It's secondhand information gleaned during this investigation. The court had not yet heard from the DCF social worker.
But she had the report.
Right, but it was not the social worker's report. And so I think that the weight of the evidence, the judge is already saying this secondhand information in this report is going to be held far higher than mother's testimony, despite having never heard from the DCF social worker himself. And that was a government witness may not be exempted from appraisal of their credibility, and I believe that is what the judge did here. And I see I'm over time, so I will rest on my brief unless the panel has any further questions.
All right. Thank you, Counselor.
Thank you.
We'll hear from the department now.
Good afternoon, Your Honors. May it please the Court, Claire Gilchrist for the Department of Children and Families. We are asking you to affirm the orders of the lower court today. There was ample evidence in this case of the parent's unfitness, beginning with mother, where the judge relied on a constellation of factors, including her inability to provide for the children's needs during her parenting time, as well as her 22-year history of substance misuse that remained unresolved at trial, and her 15-year history of domestic violence, where she had not completed domestic violence education by the end of trial. Her housing also remained unstable, and she had not been treating her mental health diagnoses, particularly her bipolar disorder, for 10 years. And as far as the the conduct of the trial, Your Honors. There was no impropriety here. The judge, although maybe his approach is unusual, he was asking questions that clarified the evidence that brought out inconsistencies.
Some of them, but I was always taught you can't ask a witness to testify about the credibility of other witnesses. And the judge specifically asked her whether the social worker is going to come here and lie. I don't understand how that's a proper question from anyone, never mind a judge.
So I think what was happening here was he was trying to understand mother's position around the evidence, why she was claiming that she was correct and the social worker was not. And that those kind of clarifying questions, we see that later in in other instances where the judge sort of drilling down, he was able to catch an error with the carry record where a wrong carry was submitted.
Let me tell you the question that I find difficult to justify. He asks her if she can prove it. If she can prove that the worker is lying. That's not the mother's burden. And yet I think it's a he, the judge quite clearly is shifting the burden to mom there, isn't the judge?
So what the judge is doing there is giving notice to mother that this is an area where there's factors that he's considering, and it's given an opportunity for her to, she has the opportunity to challenge that testimony and challenge that evidence. So he's giving her notice, that he's going to be weighing credibility, which is proper for him to do.
Based on the question, which is sort of what Justice Ditkoff just alluded to, the witness mom testifies or says he's lied about many reports. The judge's response to that is, well, we'll see if you can prove it. I'm failing to see how that's an appropriate statement. It's shifting the burden.
So on the shifting the burden piece, he's not shifting the burden in terms of proving fitness or unfitness. It's really, he's sort of putting mother on notice, you have an opportunity here to challenge this witness's statement and to provide your evidence at trial.
I agree with you, it's not shifting the burden as to fitness. And I don't know if our case law has ever sort of discussed this issue. When it comes to a credibility determination, whose burden is it? Isn't it DCF's burden to prove that their evidence is sufficient, i.e. credible, to unfitness? So if a judge is saying one of the reasons why I don't find mom is fit is for the things that you mentioned in your beginning of your argument, and it's possibly about this lying episode, how is that not shifting the burden? To prove that I'm not lying, not that DCF is telling the truth, their evidence.
So at this point in the trial, the judge isn't making a credibility determination. He's flagging issues, and he doesn't make his determinations till the end. And the record, or the findings are replete with the judge crediting mother's testimony. There are numerous findings where he credits her testimony. So it's not that he made this blanket decision, I'm not going to credit mother, and, I'm only going to credit the social worker. And additionally, there were many other pieces of evidence that went to whether mother was credible in her statements, including her own prior inconsistencies during the trial, Father One statements, statements of her parent aide and her drug use counselor, as well as police reports. So, there were all these factors that the judge was taking into consideration. And then, regarding the kiss, there's one finding 51, about it. But even if we remove that finding and say, okay, that was error, there was ample evidence that, these relationships where mother was continuing to associate with Father One and Father Two, and there was very concerning history of domestic violence.
I'm not sure it only goes to that, because if it's hard for the judge to imagine that a social worker wouldn't be credible, doesn't that give us pause about everything the judge credited from the social worker?
So I agree that, generally that would be concerning, but here the inquiry was about this specific incident of this kiss, whether it was a kiss or an embrace, in February of 2022. And the judge did have this report in front of him that had a very detailed description from the social worker of his observations there. So it's not general. Mother is attempting to paint a brush here that the judge just took this position and just completely, viewed the evidence that way for the entire trial. But there's not.
The brush that the judge is painting here is that any testimony from a social worker who, quote, has no gain in this case whatsoever is not going to lie under oath. It seems to me that is a blanket comment that I'm going to believe everything a social worker says because they have no gain in this case whatsoever. And I have a real problem with that blanket statement. How is a mother or father ever supposed to win in a situation where the social workers are going to say contrary evidence if a judge is coming in with it saying, well, they work for DCF, so they don't really have a stake in this. They're gonna be honest.
I understand your concern, Your Honor, but that's not what happened here. If you look at the findings, the judge did credit mother's testimony in numerous findings.
Is there any place where the judge discredited a social worker? I didn't see that.
Well, Your Honor,
Credited mom versus the social worker, where there was a contrary view, and he credits mom instead of the social worker. Either of those situations, is there any finding of that?
well, I think, that we run the risk of an opposite generalization, which is that social workers should not be credited unless there's evidence, positive evidence that they have not lied. And that is not our standard. The judge is weighing the testimony that they're hearing throughout the trial, and where there was ample evidence that mother was inconsistent on numerous topics, there were credibility issues on numerous topics, and there wasn't evidence that the social worker was on all these numerous topics, because there was all this corroborating evidence to what the social worker was saying, again, from the parent aide, from mother's substance use counselor, from police reports, from father's, and even mother's own conflicting statements. Your Honors, in terms of Father 1, the evidence of unfitness there was also ample. He, had not recognized the serious issues of domestic violence and just refused to participate in any services from 2020 to the end of trial. And there were also...
Let me ask, he makes the point that this is a very basic point, so bear with me, that this is just hearsay. None of these police officers came in. No eyewitnesses to domestic violence came in. Is that a fair statement? First of all, is that factually correct? I understand that in DCF, you're allowed, the proceedings, care and protection proceedings, they're allowed to rely on, the judges are allowed to rely on hearsay. That's essentially your point, right?
Yes, the hearsay was admissible, and Father had the opportunity. He could have called the officers to examine them during the trial, so he had the opportunity to challenge the testimony there. As far as Father 2, as your honors have pointed out, and even as Father 2 himself concedes, the case law does not support what Father 2 is saying. So the case law is there a bond, and the bond is to assist the child in transitioning from one home to the other, and what is in the best interest there. And here, the child was clearly bonded with and I see my time is up. If there are no further questions, I rest on my brief.
Thank you, Counselor. We'll hear from the children now.
Good afternoon. May it please the court, my name is Sandra Ferrigno, and I represent the children. We are requesting that the court affirm the decrees issued by the lower court, finding the parents unfit, terminating their parental rights, and freeing the children for adoption, as well as the decision declining to order post-termination and post-adoption visitation between Child 2 and Father 2. Child 1 was 5 years old at the time of trial and is 8 years old now. Child 2 was 2 years old at the time of trial and is 5 years old now. At the conclusion of trial in August 2023, the children had been in the same pre-adoptive foster home for almost 3 years. With respect to Father 2's argument, the standard always is the best interest of the children, and that standard is reviewed under the abuse of discretion standard, and there is no abuse of discretion here. In this case, Child 2, as you heard, was placed in her current pre-adoptive home when she was 8 months old. At the conclusion of trial, she had lived with her brother there for almost 3 years. This was essentially the only homes that she had ever known. The evidence did show that Father had only a total of 12 to 16 visits with the child over her lifetime.
Does the record give us any sense of what the pre-adoptive parent's attitude is towards non-court ordered communications and visitation?
I don't believe that that is in the record with respect to the trial. That part, I think, happened after. And as counsel stated, that motion that he filed was not part of the record. It was not appealed, so it's not properly before the court at this time. At the conclusion of the trial, Father had not seen the child in 16 months. There was evidence, and the judge did find that...
Counsel for Father 2 is suggesting, I think, that a bond, which is what our case law talks about, doesn't necessarily equate to the best interests of the child based on expert testimony. Do you have anything sort of contrary to that, other than our case law, which, by the way, we're bound to follow unless we decide to change the law?
And in the case law is the best interest of the child, and in this case, the court did find that there was not an existing bond between the father and the child at the time of trial. The court did find, however, that the child had developed a strong bond with the pre-adoptive family, and that the child did seek them out for comfort and viewed them as her psychological parents. So that evidence is in the record. As you've heard this morning, there was ample evidence to show that the parents, a finding of parental unfitness by clear and convincing evidence, and that unfitness was not temporary. You have heard that mother's history with the department spanned over 20 years, and that she was not consistently engaged in services to address her mental health, substance use, and domestic violence issues. The evidence also showed that she was inconsistent with visits with the children during the last 6 months of trial, and she was unprepared for the visits that she did attend. She often did not have diapers for the child too, and she did not have food or activities for the children. She also was not adequately supervising the children during those visits. With respect to Father 1, you also heard that he did refuse to work with DCF and participate in his services. He was also inappropriate with the child during visits, which led to some of those visits having to be canceled. In April and May of 2023, while the trial was ongoing, he missed half of his scheduled visits with the child. To touch briefly on Father 1's arguments, he does raise the issue of ineffective assistance of counsel. We know that ineffective assistance of counsel claims require a two-pronged analysis. The first is whether the behavior of counsel fell measurably below that which might be expected from an ordinary fallible lawyer, and if so, whether counsel's conduct likely deprived Father of an otherwise available substantial ground of defense. Under this prong, however, prejudice must be shown, but prejudice is not shown if there is overwhelming evidence of unfitness. This case does show that there is overwhelming evidence of Father's unfitness. Father's claim fails to show that his counsel did anything that fell below the applicable standard and was unreasonable, or neither does he point to any evidence that his attorney should have challenged, or evidence that any findings were erroneous based on that unchallenged testimony.
All right, Counselor, I think we're going to have to leave it there.
Thank you, Your Honor.
All right, that concludes the business of the court for today. I'd like to thank our court officers who always protect us and did extra duty today. I'd like to thank our timekeeper and happy birthday. I thank our clerk's office, which allows us to do everything, and of course all the attorneys, and of course the pro se litigant who argued in front of us today. And with all that being said, court will be adjourned until October 27th at 11 a.m.